final argument for this morning is State of Ohio versus Todd Cleavenger. It's case number 29-519. Each party is represented by counsel, so each of you will have 15 minutes to present your arguments to the court. Of course, appellant may reserve up to 5 minutes for rebuttal. Just let me know and I'll keep track of that time for you. We ask that you not use the names of victims or children in your arguments. That you stay at the podium, keep your voice up since these are being recorded. I can assure you that Judge Callahan, Judge Sutton, and I have read the brief, so we are prepared to proceed when you are. Let me just ask right off at the top here, are you going to reserve some time?
4 minutes. 4 minutes. 4 minutes.
It is on the screen, and I'll remind you as you get close. All right, thank you, counsel. You may proceed.
Good morning, Your Honors. May it please the Court. Max Hirsch on behalf of Todd Cleavenger. The errors that occurred below prevented Mr. Cleavenger from fully developing his alternate suspect defense, and at the same time allowed the prosecution to bolster the credibility of the complaining witness, whose testimony was vital to their case. Because the state cannot show that these errors were harmless beyond reasonable doubt, this Court should reverse. And for this oral argument, I'd like to focus on assignments of error 1 and 3. If the Court has any questions or if there's any time left, of course, I'd be happy to discuss the others. So starting with assignment of error number 1, the criminal rule 16K violation. As a threshold matter, this error was preserved for review. Defense counsel objected twice to the offending testimony, first when it began, and second when he issued a continuing objection during the sidebar discussion. That parallels what happened in the Farici case that we cited as supplemental authority out of the 8th District, where the Court there also similarly found that defense counsel's objection preserved the 16K error for appellate review. Specifically, defense counsel objected to Nurse Shield's testimony about the psyche of victims. He made clear he was not objecting to any of her observations of BO or anything that BO said to her. Counsel's statement at the very end of the sidebar, when he said, I don't have an issue with that, was a response to the statement by the trial court. It has to be read in context. The trial court said, same nurses question victims in a certain way for a certain reason. For him to acknowledge that was not inconsistent with his previous discussion. Nurse Shield certainly could describe her process of questioning BO or how she questions victims in general without necessarily needing to explain what she learned in her training. And of course, he didn't use the word withdraw or anything of that nature, so it should not be read to, or should not be construed to mean that he meant to completely withdraw the objection, even when he had issued, especially when he issued a continuing objection just moments before then. So turning to the merits, which the state has not argued in their brief, this Court should make 3 findings. First, this Court should find that Nurse Shield's testimony about the psyche of victims was expert in nature because it was based only on what she learned in her training, as opposed to her observations of BO or her observations of patients generally. And so finding this Court can look to the Camera case we cited as supplemental authority from paragraphs 113 to 115, where an otherwise lay witness who begins to give testimony about what that person learned in their training can be considered an expert witness for purposes of Rule 16K. Second, this Court should find that there was no expert report created and supplied to the defense, which I believe would be uncontested altogether. And third, this Court should find that the error was not harmless. And in so finding, this Court should look to the authorities that we've cited out of the 1st, 5th, 6th, 8th, and 11th districts. All of those cases have 2 things in common that are also present here. First, in those cases like this one, those cases primarily boil down to the credibility of the complaining witness. That's because in those cases, did not involve any corroborating forensic evidence, did not have any other direct witnesses to the charged conduct, nor did the defendant make any incriminating statements in those cases. And the Bellamy case out of the 5th is the most stark example of this. Second, in those cases like this one, the expert testimony then served to bolster the credibility of the complaining witness. Again, that witness whose testimony and credibility was crucial. And in all those cases, the courts found that the 16K error was not harmless, and this Court should find the same here. Turning to assignment of error number 3 on battered woman syndrome.
Counsel, can I go back to the
Yeah,
first assignment? Did the same nurse interview / treat BO one time or more than one time?
One time.
All right. I'm going to pose a hypothetical to you.
Absolutely.
Let's say that it was 2 times, and BO's rendition of the facts differed the second time. would you then think it would be acceptable for the same nurse to discuss why those differences might exist?
It would depend how the nurse discussed it, and if she discussed it in the same way as she did in this case, it wouldn't make a difference, and that's because her entire discussion of it was cabined in what she learned in her training. And I do have a couple of exact quotes where the questions are phrased as, so you mentioned what SANE training is generally, what does your training teach you to do as part of that training? Do you understand how time affects the victim? So, and so certainly if Nurse Shields or any nurse treated someone twice, they could certainly discuss, here's what this person said the first time, here's what the person said the second time. And it would be a different case, and this is discussed in camera, it's an entirely different case if someone says, in my experience, this is what I see happen. Like I see victims, give differing details time after time, but there's no foundation for that in this case. It's exclusively based on what she learned in her training and what the literature says.
Thank you.
Counsel, did the nurse, did she diagnose BO in any way?
And psychologically speaking,
As having a memory issue?
I don't believe so. I think the expectation was that she would be providing diagnoses and observations concerning her physical condition. And the discussion of how time affects a victim is what prompted defense counsel to raise this issue and have this discussion with the court saying, that first category I just mentioned about what she observed is totally fine, but what defense counsel started to hear is that she's going to discuss what she learned in her training, and that's what was not acceptable.
Thank you.
So turning to the third assignment of error now on battered woman syndrome, this error essentially boils down to what the Supreme Court of Ohio said in Haynes and how this court interpreted that case in Long. In Haynes, the Supreme Court of Ohio made clear that there is not a rigid set of foundational requirements when a party wants to offer BWS testimony, and it may be offered by either side. As this court said in Long, there are essentially only two requirements that the proponent has to show. First, there has to be evidence of a battering relationship between the couple, and second, there must be at least 2 cycles of violence between them. In addition, the Haynes court also noted that it's best practice, though not absolutely required, that the testimony is general in nature and it should not involve diagnosing the battered person as such. And so simply what happened here is that the trial court failed to follow Haynes and Long and added requirements not contemplated by those cases. So if this court starts reading on transcript page 611, the trial court there assumed those foundational elements and relevancy. The defense wished to recall BO for further testimony outside of the presence of the jury to establish that foundation I just mentioned. The trial court would not allow that, but what the court goes on to say is that the court assumes that if she were recalled, the defense would be able to show the battering relationship and the cycles of violence. The court also assumed relevancy when it said that BWS testimony can be relevant to explain why a battered person would accuse someone other than her batterer of inflicting her injuries. And of course, the defense counsel made clear at all times that the testimony was going to be generalized in nature. But despite that foundation, the court went on to add additional requirements that are not mentioned by those cases, and there are 2 of them. First, the court thought that BWS testimony must be rehabilitative in nature. And that's simply not correct. Nothing in Haynes or Long says that's the case. There is a passage in Haynes that talks about rehabilitation, but when it does so, it's simply talking about the timing of when it may be introduced. I think the context is the state doesn't have to wait until its rebuttal case if it wants to use it as rehabilitative. But nothing in Haynes says it must be rehabilitative in nature, even if that is conceivably how it is often used in practice. Second, the court believed that the testimony must essentially explain a contradiction. So when a person says one thing at one time or perhaps recants. And again, I'll acknowledge that's commonly how it's used, especially by the state, but I urge this court to look closely at Haynes and Long. Nothing says it must explain a contradiction. What it boils down to is that either side can offer it as long as that foundation concerning the battering relationship and cycles of violence can be offered. I'd also note for this court that even setting aside the trial court's assumptions, the record also does establish the foundation of a battering relationship and the cycles of violence. That comes out in the testimony of BO, of Mr. Tipple, and of the proffered Exhibit E, which establishes that at the time of the 2012 incident between the 2 of them, Mr. Tipple had been beating BO for years at that time. So even without the assumptions, the record establishes it as well. So by assuming the foundation and by having the relevant foundation available, but nonetheless adding requirements not required by the controlling cases, the court abused its discretion to disallow the testimony. I'll reserve or I guess I'll quickly touch on a couple things on 404B just to highlight for this court. I won't go through the entire argument, but one thing I want to note about reverse 404B is the 2nd and 6th districts, which have expressly adopted that standard. If your honors look at those cases, there's no indication that the trial court in those cases considered the other act's evidence under a reverse 404B standard. So I just want to note that by having brought it up under 404B in general and having the evidence relate to a third party, this court can also reach reverse 404B, even though the trial court did not in this case. But of course, if this court does find that the Williams three-part analysis is appropriate, we can still be, it still should have been admitted. And of course, since we submitted the supplemental authority, I guess I just want to address that really quickly. So the two cases we cited that relate most directly to 404B are the Singfield and Safaris cases, and broadly speaking, what those stand for is that the type of victim, so in this case we're talking about someone's romantic partners, oftentimes the mothers of this person's children, the time the assault takes place, and the location of the previous assault or previous events, those are all relevant to go towards identity. So of course in this case there's no one thing that's I'll say is an MO, but it's all these factors weave together that create the substantial enough similarity for such that the evidence should have been admitted. And unless the court has any other questions, I'll
Is
reserve.
there any Ohio case law that, or any of those cases for the supplemental cases, holding that a defendant can introduce the battered or women's shelter testimony, to argue that the victim was battered by a third person?
So try as I might, I tried to find a case anywhere that established that, but we don't need to show that simply because of the permissiveness of Haynes. And there's even a discussion in the trial court below in this case where the prosecutor even agrees, as long as the defense can establish the same foundation that we're always held to, it can be admitted. So no, and unfortunately I couldn't find an identical situation, but as long as Haynes is met, which it was, it should have been admitted.
All right, and with that, as long as there's no other questions.
I have one question. So just so I understand, what you're arguing is that under Haynes, that it is permitted to use the battered women syndrome evidence to impeach the credibility of the victim.
Effectively, yes, that's what would be happening here. So I acknowledge that, but I'd also say that nothing in Haynes prohibits that situation. It doesn't talk about any requirement concerning rehabilitation or impeachment or anything of that nature. I mean, maybe more precisely, I'd say it's just providing an alternate explanation for why some of the events played out the way they did in this case. And the defense counsel would just simply be able to argue that on close, and the jury would be free to obviously believe or disbelieve that given the circumstances.
And counsel, just following that a little bit further, was there testimony presented about some of the incidents that you are seeking to bring in this realm?
Only very vaguely. I mean, B.O. and Mr. Tipple both acknowledged that there have been physical incidents or physical altercations between them, but the reason the 404B, or the reverse 404B is crucial is because the similarity of those acts didn't come out, and since identity was the central issue at trial, it's the similarity of those issues, and if the jury had learned that they could consider it as to the identity of the assailant. So the specifics would have made a difference.
Thank you.
All right, that leaves you with 2 minutes and 2 seconds for rebuttal. Counsel, you will have 15 minutes.
Thank you, Your Honor. Counsel? Good morning, and may it please the court. I'm Jacqueline Corgan on behalf of the state of Ohio to urge this court to affirm Mr. Clevenger's conviction. The state, of course, respectfully argues that this conviction should be affirmed because the trial court in this case, regarding any or all of the 4 evidentiary rulings about which Mr. Clevenger complains today, the trial court did not commit any error in any of those rulings. And I understand, based on the arguments that counsel is focusing today on assignments of error 1 and 3, under Assignment Earth 1, the estate would posit that this is actually a non-issue for this reason. Mr. Cleavenger wants a new trial because the same nurse in this case who examined the victim in this case and documented her injuries said that victims sometimes don't recite what happened to them in a clear timeline, that she questioned the victim about the events that caused her injuries, that the victim's tearful but calm demeanor was A, typical for someone with victim's injuries in the nurse's experience, and that based upon the nurse's experience as a nurse, that this was also typical in the nurse's experience. And then because the nurse did not provide an expert report. The state argues that none of that was expert testimony. The state also still posits that this issue was forfeited because it was really not preserved. And this is one of the things that is well laid out in the briefs, that the quotations from the record, where it's not preserved because after counsel stated that the trial court's narrowing of the state's questioning to this nurse would be acceptable to trial counsel, the state complied with the trial court's instruction on narrowing the questioning of the nurse, and there was no objection to that thereafter. So, again, there were no further objections to that after the trial court narrowed the line of questioning, and the state complied with that. Even if that was preserved properly for the purposes of this appeal. Again, there was no error, because under Evidence Rule 701, a lay witness may offer an opinion if that opinion is based upon that witness's perception and is helpful to form a clear understanding of that witness's testimony or the determination of the issues. So for instance, this court has already ruled in it's from 2020, I'm not sure exactly how to pronounce the case, but we cited in our brief, that the operation of how Snapchat works does not require expert testimony. But in addition, getting to Kamer, the case that counsel has cited in the Third Supplemental Authority, the reason why the same nurse and her testimony was objectionable and improper in the Sixth Circuit or the Sixth District's opinion was that she gave 3 reasons why it might not be surprising for the child victim of a sexual assault to report that she was in current pain. And also, the prosecution laid no foundation with that particular nurse regarding her experience, training as a nurse, and her testimony was not based upon her personal knowledge. Nevertheless, that court found that error was harmless. In this case, I'd like to remind the court of what the nurse in this case did not say. She did not say that the victim in this case either did or did not recite the events in a kind of logical or linear fashion, offered no opinion or no indication of that. She also did not state that there was anything that would explain victims' account for the events. So she did not offer any opinion as to the quality or logic of the victim's recitation of what had happened to her. She also did not offer any opinion as to who inflicted these horrific injuries on the victim or how they were inflicted. In addition, in this case, there was a foundation laid to show that this nurse's testimony was based on her observations of this victim and her observations of other people based upon her professional experience. She testified that in addition to her degree, she had been a nurse at Barberton Hospital for 5 years. In addition to her degree, she had 5 certifications that included her same nurse certification. And she also explained the same nurse training. But why is this harmless. I'm going to review for the court very briefly because I know my time is limited. What's not in dispute in this case? This is the evidence that's not in dispute. First of all, the victim is a victim. Even defendant's counsel stated that to the jury during this case. She is a victim. His only dispute was who was the person who victimized her. It's also not in dispute that Mr. Cleavenger took photographs of this victim while she was naked and beaten and on her daughter's bed at 4:21 a.m. It's also not in dispute that Mr. Cleavenger, despite being in the victim's house and taking photographs of her injuries hours before she was treated by anybody in medical fashion, never called 911, never took this victim to the hospital. The victim instead beat on the back door of her neighbor's house at 6:30 a.m., clad only in a fitted bedsheet in the dead of winter on New Year's Day. At that point, who does victim say beat her? She tells her neighbor, Todd Cleavenger beat her. Her injuries were visible to her neighbor. Her neighbor testified that she barely recognized her, even though she had known her for quite some time. It is the neighbor who calls 911. Police and EMTs arrive around 7:20 a.m., about roughly 50 minutes after the victim beats on the back door of her neighbor. The victim tells police at that point that it is Mr. Cleavenger who beat her. The police wind up surrounding the victim's home. They see somebody try to leave through the back door but changes their mind. One officer looks through a window, sees what victim later describes, a bed with no sheets, no blankets. Then police beat on the door of that victim for 15 minutes, telling Mr. Cleavenger to leave the victim's house. He does not. They end up using a battering ram to break in her front door. When they do, they encounter resistance. The door won't immediately open. When they go to kick it next, then it opens. So they testify that they believed that someone was holding that door shut. Then there was one person inside that victim's home when police broke down that door and gained entry. And that was Mr. Cleavenger. And when they did, Mr. Cleavenger held up the victim's cell phone as if he were videotaping the police officers. Then, Mr. Cleavenger doesn't tell police anything, doesn't say to them, hey, the BO is injured somewhere in this house. Doesn't seek help for her at all. Then, but by that time, the EMTs have taken the victim to Barberton Hospital, where she tells the same nurse the same story she's told the neighbor and the police officers. Todd Cleavenger beat me. Then, after the victim arrives back home, after being hours at the emergency room, she finds her house keys and Mr. Cleavenger's cell phone behind her TV stand. Now, the reason that that's all overwhelming is that here are some of the questions that the jury could have asked itself when hearing all this evidence and deliberating. Why did Mr. Cleavenger take photographs? Why did he not call 911 when confronted with somebody who was beaten as badly as she was? Why didn't he open the door for the police? Why did he block the door when police tried to gain entry? Why did he film or behave as though he were filming police officers when they came in? Why did he not say, there's an injured woman in here and she needs help? Why did he take all these actions or commit these inactions unless he was the person who beat her? And it is on that evidence that the state posits that this alleged error regarding the same nurse, and indeed all the other errors that Mr. Cleavenger claims, are all harmless beyond a reasonable doubt. Now, moving on to the battered women syndrome. As I understand, my time also is limited. I would remind the court that the Supreme Court of Ohio in State versus Haynes outlined 3 permissible purposes in Ohio that Ohio will recognize for the use of battered women syndrome. The first is by the defendant, and that is when she, the person who has been battered, is using it to establish self-defense when she uses force to defend herself. The second purpose is for the use by the prosecution, and that is to explain a victim's recantation, which did not occur here. This victim has never recanted her story of who beat her. There's only one person she has consistently identified from the get-go as the person who inflicted, 8 head injuries, including a broken nose and a concussion, and a laundry list of other bruises and injuries. And that's Todd Cleavenger. The third permissible purpose is to explain why a victim would not leave an abusive relationship. Well, in the abusive relationship that Mr. Cleavenger posits this court should examine, this victim did leave that abusive relationship. She testified that she had left it 6 years before this incident. And in all of the other instances where battered women's syndrome is used, we have an immediacy of the relationship or the battering is close in time to the action that's being charged or the action that's sought to be explained. So, again, under Haynes there are 3 permissible purposes, but also moving on to the relevance under Cost and under Haynes, which the trial court outlined when it made its decision to bar Mr. Clevenger's use of the battered women's syndrome. They have to lay a foundation that the party or witness is indeed a battered woman, which means that there were 2 or more cycles of violence with this abuser. And then there has to be evidence that the victim behaved in a way that would be puzzling to the jury. In other words, the kind of behavior for which we would need expert testimony to explain her behavior. So, because remember, under 702, you do need expert testimony when it's helpful to the jury and when it's something that would be beyond the ken of an average juror. Well, when you have a recantation or not leaving an abusive relationship or explaining aspects of the self-defense defense, you would need an expert witness to testify regarding battered women's syndrome in those situations. In addition, expert testimony of that type has to still conform to the other rules of evidence, including, and that's partly 290106. And as the trial court noted, lots of the evidence that Mr. Clevenger sought to introduce, for instance, to establish a pattern of abuse, that cycle of abuse, was reverse 404B evidence, which the state posits was properly excluded by the trial court. And that's under Hartman and Smith decisions. There still has to be, evidence has to be offered for a non-propensity purpose, and also that has to, its potential for unfair prejudice has to not substantially outweigh the probative value of the evidence. And this court is well familiar with those having decided so far as recently.
4 seconds.
All right. I would remind the court that Mr. Clevenger's reverse 404B evidence fails that first step. It was clearly propensity evidence, which has not been permitted under 404 nor the common law. And I will just leave this court with a quote by the defense counsel that it was the defendant's position, and this is at page 24 of the trial transcript, that the victim's prior injury is very identifying of KT. And that's not something that you grow out of, and he did it again on this day. So, bottom line, What Mr. Cleavenger wanted to use this for was to show that KT had a propensity to beat women and beat this victim on that day. That is absolutely not permitted. And
Counsel, you're
for,
out of time.
thank you very much, I urge you to affirm.
Thank you. And, Counsel, you have 2 minutes, and the prosecutor will go about a minute over, so I'll give you 3 minutes.
Okay, thank you. I have 3 points I'll try to reach here. To begin with, responding to what my colleague on the other side said about the first assignment of error, when this court goes back and looks at the record at the beginning of Nurse Shields' testimony, and it's not to split hair, it's not to split hairs, this distinction matters whether Nurse Shields says this is something that was in her experience or whether it's something she learned in her training. That matters. The Camera Court said that matters. The Camera Court discusses an 8th District case called Bell, in which the court appreciates that difference. Here, Nurse Shields' testimony was in the language of what she learned in her training, and that's why it was expert in nature. Second, Nurse Shields' testimony about what she learned in her training was not narrowed. She continued to elaborate after the sidebar discussion about the timeline issue, about how victims don't tend to remember things over time. In both the prosecutor's initial closing and rebuttal closing, the prosecutor cited to Nurse Shields' testimony explaining that's why BO gave some information at one time and some information at another time. So not only was it not narrowed, but the prosecutor also relied on it at closing, which compounded the prejudice here. And finally, defense counsel did not need to raise any further objections. He objected contemporaneously and issued a continuing objection. The state's only case in their brief on that issue involves a case where no objection was raised. Second, again, my colleague on the other side here recited many facts that are not in dispute, but those facts are not direct evidence of identity. For one to believe that those facts are evidence of guilt requires a person in the first instance to believe BO's version of events. If one does believe that, then sure, one could interpret them as necessarily being evidence of guilt, but they're not. The sole dispute was, did an assault occur in the home? And not only was that not supported by any forensic evidence or any other eyewitnesses, but much of the police testimony about what they observed in the home directly contradicted what BO said happened, such as her saying that she was thrown into the windows, causing them to be broken. Police did not observe broken windows. Police said, we observed no signs of a struggle, no sign of blood or anything. They didn't call any further forensic analysis. As for the blankets, I just want to point out on transcript page 525, Officer Mingle testifies that when I first looked in, like I said, I don't recall if those were actually there or not, so it's not as definitive as the state makes it out to be concerning whether the blankets were there or not. I see I have about 30 seconds left. I'll just touch on BWS. Again, Haynes doesn't have a laundry list of permissible purposes concerning battered woman syndrome. The parties below agreed that the issue is just simply whether the foundation is met and whether there is relevancy, of course, subject to all the other rules of evidence. And I'm not aware of any case, and I don't believe the state cited any, that said that 404B other acts are a threshold issue in determining whether BWS testimony could be admitted. Certainly the expert here was simply going to provide general information about the phenomenon, so that could have been admitted without necessarily needing to go into Mr. Tipple's past acts.
All right, with that, counsel, your time is up.
Thank you.
Well, I want to thank both of you for excellent arguments on a very interesting case. So thank you for being here today and for your presentations. Court will take the matter under advisement and issue a decision in due course. Clerk of Courts will mail each of you a copy of the decision on the day it's released, and the opinions are posted on the Supreme Court of Ohio's website. Again, on behalf